So the question asked to me is there are two types of bench decisions, one that finds you disabled and one that explains the rationale. Actually, a bench decision is this is where people kind of get confused. A bench decision does both. It finds you disabled and it also explains the rationale for why you're disabled. A bench decision typically is one where the judge writes the decision there. Let me kind of explain to you what typically happens. Typically, when the judge has the hearing, the judge takes that information, provides that, and basically uses it as a template to basically form the basis of their decision with the explanation of why they believe in favor one way or the other. They then take that information, make it available to a decision writer, an attorney decision writer, who will take that information, write the decision for the judge, and then once that decision is written, another part of the agency will put together the boilerplate information that has to be formed with it. Judge reviews it all, signs it, is sent out. Now, those steps can usually take about a month or longer to happen, maybe even 2 months, depending on the circuit or jurisdiction you're in. A bench decision means that the judge right there wrote your decision, meaning there's nothing for anybody to do. All they have to do is basically write it there. Like it used to be back in the day. I haven't had this happen in years because it's electronic. But back in the day, you get a bench decision, the judge would actually hand you the decision right there. I hadn't had that happen in a long time. But this is almost in the same instance, because what happens is the judge, it doesn't have to go into post-review or post-development, because what happens is this. Decision, it goes into post-review. Post-review is where the judge writes the decision up. It goes to pending decision writer, which means it waits for a decision writer to get assigned to it. Goes into decision writing mode, where it basically is written and put together in its final format, and then it's closed when you get approved or whatever, or you get denied. Think about it. You've got hearing, post, pending, decision writing, closed. 5 steps. Guess what the judge does? With a bench decision, he takes over about 3 of those. There is no post review. There is no pending decision writing. There is no decision writing per se. Basically, you go from the hearing to the decision writing. He basically takes off 2 steps. Hearing to decision writing. Decision writing shouldn't take that long. Finalize it, boom, close it, and gets right to you. And they both do the same thing. It tells you why you're disabled, and it finds you disabled. Most times they do bench decisions. I've never had a bench decision for denial. Most of them are for approvals. And a lot of times the judges are doing that because they want to help you get your case processed through in a faster manner, and you're not sitting around waiting.